to our class on American corporate law. This is another class where the field that's being studied is immense. So this isn't meant to teach you too much about corporate law. Just impart some basic vocabulary. Just basically teach you the key terms that you have to know, and hopefully you can do your own research on your own corporate matters, because I understand this influences a lot, and it's not really the area that I expertise in. So it really we're just going to go over the basics in terms of vocabulary today. So incorporation, it's basically when you want to found a company, you have to have articles of incorporation. You have to say how the company is going to operate, and the companies, if they're publicly traded, they have a board of directors, and that board of directors is going to make decisions. They're going to hire someone like a CEO, so that's going to be the chief executive officer who's going to make the decisions for the company. They can have a chief financial officer. So there's plenty of leeway to how the company is operated. But obviously, the most important aspects of this regulation is more so on protecting shareholders, so that they'll have confidence in the system. The structure, usually, you have your board of directors, your shareholders. The shareholders being, the people who own the company. The board of directors is sort of making decisions, and then the chief executive officer, operating the day-to-day activities of the company. This isn't different from how we do things when we think about, large publicly traded corporations. Limited liability is important because this is what makes a corporation effectively useful. The idea that you don't have to, if you are a small person and you have, your own small business, you have the limited liability. So you're not going to be personally at jeopardy with all your personal wealth if the company does not go well. The fiduciary duties, this is important. This is extremely important when we're talking about the behavior of the people working for the board of directors, because it's basically when you have a fiduciary obligation, you have to put the company's interests before your own. So if you're the CEO, you have to prioritize the company before yourself. Basically, that's a fiduciary obligation. The corporate governance, you have your board of directors. Usually, when the company is publicly traded, you have people who have non-voting shares. Those shareholders. There's going to be the majority of shareholders, and then you're going to have the people on the board of directors. Going to be usually larger shareholders, and those people are actually going to vote on things, and they're going to appoint CEOs or dismiss CEOs at their own discretion. The securities regulation, basically, the idea of securities is sort of similar to the idea here that we have, when we talk about stocks or these things that are publicly traded that pertain to the company. Those are securities. So the Security Exchange Commission, it's the SEC, is the organ that is responsible for regulating that, and it was created in the 1930s with the Securities Exchange Act as a response to the completely unregulated market that led to the 1929 Wall Street crash. And there have been many attempts at improving these regulations, because there's still a lot of malfeasance and bad behavior in the sector, which is why the SEC has consistently updated its rules, even though there's been several pieces of legislation to help them do that. So when you think of something like the Dodd-Frank Act, which was something that was passed to limit the bank's ability to engage in this sort of financial manipulation as a response to the 2008 financial crash. So it's something that's always being updated, and it's really long and complicated, and it's really important. Hopefully you can take the basic vocabulary here and apply it to your own research on the matter, because it really is it's a field with a lot of regulations and a lot of exceptions to those regulations as well. Taxation, obviously a big part of any corporate structure. Basically, you have to pay the taxation. There's the capital gains tax, which is something we don't have here. You have to pay capital gains being, when you sell stocks, or there's a profit tax when you profit off a corporation. So there's a lot of different forms of taxation when we're talking about the corporate world. The stock market, obviously, this is we know it well. Basically, the stocks being these unit ownerships that represent a part of the company. Some of them are being voting stocks, many being non-voting stocks. They're publicly traded at the stock market, such as the Nasdaq or the New York Stock Exchange. And that usually happens through a broker. So a broker will trade stocks for you, or a hedge fund. A hedge fund is basically a group of experts that you can entrust your own money with if you have a large sum of money, and they will make investments on your behalf on things they think are going to do well, or maybe they're going to try to gain the market in some way. The dividends would be the portion of profits that you're entitled to as a result of being a shareholder. If you own stock, you're entitled to a portion of the profits. The IPO, these are all the same terms we use here because really we are hugely influenced by these things here. So this is not news, I think, to anyone. But the IPO being the initial public offering, when a company goes public, because not all companies are publicly traded, even some large companies are not publicly traded. So when they do go public for the first time, they have an IPO. So it's the first time these stocks are being offered to the public. Usually it's a big event. It's something that makes the companies anxious because maybe it will well, maybe it will not go so well. The bull and bear market, those are really not legal terms. Those are more terms of, that you use in your day-to-day investing life. So bull and bear market, the bull market being, a positive, growing stock price, the bull market being usually associated with the good thing, and the bear market being a bad thing, the decrease in stock value. You can make money off both situations, but basically usually a bull market would be, a market that's doing well. Hedge funds, like I said, they pull capital from several wealthy individuals that are not really available for normal people. Basically, they do investments, some of them being very high risk. Derivative investments meaning that you short the stock, meaning that you sort of bet against it. So basically, when you short a stock, you borrow it from someone else, and then you sell it, and then later when the stock price collapses, you buy another piece of that stock, and then you give it back. So you're borrowing and selling something that isn't yours. It's the kind of a manipulation and almost magical thinking that goes into the stock market. And there's a lot of criticism about derivative investments in the stock market. But this is just one of the many things that hedge funds do. But usually, they combine these high risk and these low risk investments, which is why the wealthy individuals go there. Because there's a multitude of different investments being done, and there's a good chance to get a return on the money that you put in. Here, this is very important. Dodge versus Ford Motor Company. Basically, this is a very old case. So this decision here, Dodge versus Ford Motor Company, is basically when the company was actually run by its founder, Ford. He had the idea of it was almost motivated by politics to expand his company, give people more cars and more jobs. The shareholders are saying, well, is this going to result in increased profit for us? He wasn't sure. So basically they're saying, well, under the idea of fiduciary obligation, you can't think about really the company in terms of how much good it does to the employees. You have to think of how much good it does to the shareholders. You have to think of how much profit it brings. You're not allowed to think, well, I'm going to do this because it's going to help the community. You have to think, well, I'm going to do this because it's going to help the shareholders. So it's a good illustration of what a fiduciary obligation is. Well, basically in this case here, SEC versus Texas Gulf Surfer Corporation, basically what happened was insider trading. So you're trading with privileged information in a way that might damage the company. So you're not allowed to do that because this is a reflection of a fiduciary obligation. You have to put the good of the company before your own, and you cannot violate the rules from the SEC. So insider trading would be using privileged information that you're supposed to disclose in a way that harms the market and the company. Well, basically that's what happened here. There was a leak, and some people inside used that to manipulate the market. So insider trading a public company, it has to be a public company stock. Like I said, not all companies have publicly traded stocks. Trading a public company stocks by someone who has non-public material information about the company. So material information basically has to be material information that matters. It cannot be just anything, it cannot just be a hunch. It has to be material information, something relevant that which isn't available to the general public. Because if the stocks are traded publicly, you cannot profit off this private information because that will lead to a lot of backhanded, shady dealings. It has to be public so that the market can still trust the stock. If you want your communications to be transparent and you don't want to get in trouble with the SEC, you can follow their guidelines for communications and behavior. Then we have the Sherman Antitrust Act of 1890, and this was a response to the monopolization of the oil market, which was emergent. Basically, the Sherman Antitrust Act prevents monopolies from happening. If a company gets too big, it has to be broken up, or a merger between two companies which would constitute a monopoly can be prevented through the Sherman Antitrust Act. This would happen in the U.S. Microsoft case, because obviously people are arguing Microsoft dominates the computer market, the personal computer market almost entirely. Does that not constitute a monopoly? And that came up in the 1990s. And you had, and ultimately, you can see here some guidelines for interpreting the Sherman Antitrust Act. So things for instance, the predominant share, or firm violates Sherman's Act monopolization. only when it acquires or maintains or attempts to acquire or maintain a monopoly by engaging in exclusionary conduct distinguished from growth or development as a consequence of superior conduct, business acumen, or historical accidents. Basically, you're not violating the Sherman Antitrust Act if your product is so good that it takes over the market. You're doing it if you engage in anti-competitive behavior. So you sabotage your competitors, or you buy up all the small companies to prevent them from being a threat to you. So those things are anti-competitive and they're a violation of the Sherman Antitrust Act. A historical accident, maybe there was no demand for your product, which only you made, but now there is. So that's a historical accident, also not a violation of the Sherman Antitrust Act. Tying violation, we refer to this as the idea of a venda casada. Basically, when your company has a big say on the market and they force you to buy several products at once, and you can't really get the product anywhere else. So this was being done in the context of Microsoft requiring people to buy several pieces of software at once, and because they were really the only large corporation in the market that could be interpreted as a tying violation. Basically, you're not allowed to do that because that would be anti-competitive behavior if you're profiting off the fact that only you can sell those things and you sell them all together. Bankruptcy is an important part of corporate law. And in the United States, it applies to both individuals and corporations, and even some public entities such as municipalities. And there's special titles in the United States Bankruptcy Code for each one of those things. For us, the most important part would be for corporations. The idea of bankruptcy for individuals is a bit alien to us, but there are several forms of individual bankruptcy in the United States Bankruptcy Code. We are more concerned here with Chapter 7. So Chapter 7 would be a complete bankruptcy. It would be what we refer to as, falencia. Basically, all your assets are going to be liquidated. Everything is going to be used to pay off the creditors. So this is good because it can be used for individuals and corporations. Obviously, the corporation would be terminated if that happened, but the individual would be able to get rid of their debt. But obviously, they have to liquidate their assets. And, it should be pointed out that even for individuals, there's a cost to declaring Chapter 7 bankruptcy. It's not always a foregone conclusion that you're going to be able to do it. You're going to have to pay fees, you're going to have to consult with attorneys. It's not very easy, and that's by design. Chapter 11, this is for individuals and businesses. Basically, you can reorganize your debt. If you're not all debt, but you still have a lot of assets, you can reorganize your debt and still remain in control of your own finances. So this would be something like similar, but obviously many, many differences. Just trying to point out similarities with the idea of a recuperação judicial, but really very, very different. It's the closest term, but it's still very far apart. And there are other chapters other than Chapter 7 and 11 in the Bankruptcy Code. So you'd have to study all of them individually and in great detail. And then Chapter 13, this is for individuals, and this is a form of bankruptcy, which the individual can still hold on to some assets, but it's problematic because they're going to be forced to give up a large part of the income, and if they miss the payments in the bankruptcy deal under Chapter 13, the whole thing sort of starts over. It's basically not a very advantageous, but it is something that is cheaper than Chapter 7. And usually companies want the consumers to declare Chapter 13 bankruptcy because that way they can continue to profit off, the debt. Also, worth pointing out that there are a lot of sorts of debt that are exempt from the bankruptcy relief. For instance, student debt that is exempt from bankruptcy relief. So declaring bankruptcy will not rid you of your student debt. So here's some relevant case law. Again, very, very basic stuff, just for some vocabulary. Basically what I used to prepare this lesson. But I would certainly, this one is very interesting. It's more of a constitutional law thing. Citizens United, we're talking about corporate speech, which we did mention in the constitutional law class. It is something that is protected with certain limitations. You cannot do it in a fraudulent way, but they decided in this case that corporations were allowed to donate large sums of money to political actions committee and to participate in elections. But like I said, we're looking at hundreds and thousands of cases. So it's a huge body of case law that you have to be familiar with in order to have any success as an attorney in America. So here, really, we're just trying to learn the vocabulary. So yeah, I'll see you in the next lesson.